Good morning, Mr. Mantle.
Good morning, my lady.
Yes, I assume that you've both split up the time between you and that you are both fully aware of the fact that we must rise at 4:45 today.
Yes, and obviously I will be finished before then, so my learned friend, I anticipate, will have some time before then, before continuing in the morning.
Lovely. Thank you very much, Mr. Mantle.
Well, I think you're aware that, my lords, my lady, that I appear on behalf of the Commissioners for Her Majesty's Revenue and Customs. My learned friend, Mr. Firth KC, appears for Colchester Institute Corporation, which is a further education corporation. I think, check that you have the bundles. There's a core bundle, a supplementary bundle, an authority bundle, and I believe my learned friend has provided you with a short supplementary authorities bundle.
Yes, thank you. I have that.
I have it electronically at the moment, but a hard copy is, I'm sure, winging its way.
I'm grateful, my lord. I'm sure that will be provided.
You can assume that we have read quite widely, Mr. Mantle.
That's a very helpful indication, and in particular, that may mean that I don't have to take you now at an early stage to the findings of fact in this case, which are conveniently set out in the core bundle at page 72 as Annex A to the Upper Tribunal 2024's decision.
I think perhaps we should be certain of the facts on which we're proceeding. So, page 72.
74
that's
in the core.
Oh, the annex. The annex, I think, is at 72.
I'm sorry if I've given you a slightly wrong.
No, it's the. You're looking for the annex to the decision. Yes.
Indeed, I am.
Yes. Mm-hmm.
Yes, and indeed it is at 72. My apologies.
No, it's fine.
The critical thing is perhaps just to see that again, and so perhaps if I could just let you read that, or if it's not necessary.
Well, if you'd like to point out what you say are the the core issues that we must take into account as being facts found.
Yes. You'll see at paragraph 3 that we are that we're dealing with a particular prescribed accounting period, 31st November 2015, 31st of January 2016, because we're dealing with an assessment of that period, and that was in a particular academic year, the 2015-2016 academic year. And of course, it's critical that CIC, as with other further education colleges, and I may well refer to them as FECs, was funded principally by 3 government funding agencies, 2 of which we're concerned with in this appeal, the Skills Funding Agency and the Education Funding Agency. And at 4 and 5, you can see the categories of students in relation to which the EFA and the SFA provided funding. At 6, it can be noted, although we submit it's not of any significance, that the college did provide tuition to students who paid full fees, who weren't eligible for EFA or SFA funding. And the college provides courses for students from 16 upwards, and my learned friend places some reliance on the fact that students of all ages are educated or trained together. There's no separation on grounds of age. I'm going to take you to the statutory background shortly, if I may, of both the funding agencies and further education colleges. But you'll see in paragraph 8 that agreements were entered into by CIC with the EFA and the SFA which can be said to be on standard terms. And you'll see at 9 that neither the SFA nor the EFA agreement set out the courses that CIC had to provide, although there was a broad requirement that courses had to lead to qualifications, which were approved by the government, of which there were very many. And you'll see at 10 that the amount paid by the funding by the EFA, the CIC, for any year is calculated on the basis of a national funding formula, which incorporates various factors. One of the factors...
Just on that paragraph, the 2020 decision puts a bit of flesh on that bone, breaking up the different elements that gave rise to the EFA and SFA funding formulae. Now, although this is not an appeal from that decision, plainly the reason you're here is you're looking to challenge it.
Yes.
Do you accept that there's no factual difference between the position as it was before the 2020 and 2024 UTs?
No, HMRC accept that.
Thank you.
Yes, but there is more in that decision, which I'm likely to refer to, if I may, as the UT 2020 decision, or CIC UT 2020 for speed. And you'll see some of the factors there. But essentially, it's student numbers from prior years, student retention, a factor for provision of higher cost subjects, and then additional funding for disadvantaged students and possibly area costs. So in the national funding formula, there could be an uplift for area costs, such as for London and the South East, although Colchester itself didn't receive any uplift in its formula. And the other elements we see there is essentially for high needs students. And the formula is set out in the next paragraph. And then I think we can move to the amount paid by the SFA, which you see at paragraph 13, based on a monetary funding allocation calculated before the start of the year, but subject to a clawback for under delivery against allocation. No additional payments are made for over delivery. Situation in relation to the EFA is somewhat different, and I'll come back to it because we don't accept the analysis or implications of the retention in subsequent years to the relevant academic year in question that was made by CIC UT 2020 in its reason.
And again, when we come to that, I would find it helpful if you were able to tie us back to the provisions in the relevant agreements where those clawback/retention arrangements feature.
I'll do my best to do that. Of course, in relation to the EFA, there is no clawback, and there is no provision dealing with over delivery. And when we come to look and see the Upper Tribunal 2020's analysis, it's based on how the funding will be calculated for the academic year after, say, the academic year that we're concerned with here, or the period that we're concerned with here. And may be necessary just to take you to a receipt. Could I just ask you to read paragraph 15 on receipts? And you'll see in paragraph 16, essentially if you took all the figures on the receipts, those figures wouldn't marry up with the, for a year, wouldn't marry up with the funding given by the EFA, and similar kinds of issues arise with the SFA. Having just gone back to the facts, just let me tell you my intended structure. After an introduction, I'm going to take you briefly to the statutory background, including by way of the legislation relating to the Secretary of State, and so the funding agencies, and also to further education colleges. And then essentially following the order of my two grounds of appeal, I'm going to deal with the error we allege that the tribunal, the Upper Tribunal 2020 made in relation to the CJU case of Rayon d'Or, in holding that it couldn't be distinguished. And I'm going to deal first with distinctions on the facts, material distinctions more generally, and then after that make submissions to you on Rayon being a Kenema type supply or a permanent availability of the service provider to provide service supply, and the significance of that in terms of consideration and finding a direct link between the particular service supplied and the proposed consideration for it. And then I'm going to address the requirements of the direct link test and the errors that we say, the errors of law we say, that the 2020 Upper Tribunal made in relation to the direct link test. We submit in introduction that funding given by the funding agencies to further education colleges is not consideration for supplies of services of education and training provided by FECs to students. If it pleases, I'm going to refer to education to stand for both education and training. Mm-hmm. I think to an extent training may be more common, but education will serve no usage in my skeleton. So the submission I've just made begs a rhetorical question of what is the funding in the VAT context that further education colleges receive from the funding agencies. We say it's the funding of a further education college by central government funding agencies, so that further education colleges can provide training and education to young people who fall into certain categories which the government have decided should not be charged for further education. Or in other words, who should be provided with education for free. So it's the funding, we say, of certain activities of providing education by the central government, and not the purchasing of particular supplies of education. And in terms of economic realism and social realism, that second model is a well-known model. A government may fund an organisation so that it can provide services for free to final consumers. And in doing so, the government is not purchasing any supplies to be made to those final consumers. There are obvious examples in the sphere of education of government or local authority funded schools, and then there is the funding of NHS bodies. And in this modern age, in this millennium, it's not surprising that funding comes with conditions to improve efficiency of the person receiving funding and effective use of the funding by the body to whom it's granted, and indeed to impose accountability and permit monitoring of the use of the funding, not least to ensure that it's used for the intended purposes. Although I'm not going to take you to the case now, I think I'll probably have time to come back and take you to it. The South African Tourist Board case in the Upper Tribunal, in which Mrs. Justice Rose, as she then was, discussed such arrangements, including the normality, if I can call it that, of funding arrangements with conditions. So the fact that, in addition to the statutory background that I'm going to take you now, there are agreements between the funding agencies and further education colleges such as CIC, and that those agreements impose conditions, sometimes quite specific conditions, is not any indication that there must be a supply of services for consideration, either a supply of services for consideration by a body to the funding agency, or a supply of services funded by the funding agency, which are supplies made to consumers for consideration. And we say that when you step back in this case, having appreciated the detail, that level of economic reality, this is a scenario which is different from a funder purchasing goods and services for the benefit of citizens or consumers, such as a student seeking education. Rather, it's the funding of a further education college so that it can carry out its core objectives. And just before I move on to the statutory background, there are two important preliminary points. One, it's not contended by CIC in this appeal, just as it wasn't contended in the UT 2020 appeal, that the funding payments made by the funding agencies are consideration for any supply by CIC to the funding agencies themselves. CIC contends that the funding from the funding agencies is third-party consideration. The GFA, sorry, the funding agencies being the third party, but the supplies are actually made, the direction of the supply is from CIC to its students. And that's important when we come to consider consideration and whether the necessary direct link is established in this case, and indeed whether the UT 2020 Tribunal took the correct approach to the direct link. Because, of course, there will be many thousands of supplies each year for VAT purposes, undoubtedly separate individual supplies to each individual student who's provided with education by CIC. So if there's consideration at all in this case, the third-party consideration has to be consideration in return for each of those very many supplies to students. Now, there's no doubt, and it's common ground, and always has been, that consideration coming from a third party can be consideration for VAT purposes. Of course, the different factual matrix between third-party consideration and consideration received by the supplier from the recipient of the supply can raise different concerns, we submit, in terms of whether a payment is indeed consideration for supply for VAT purposes. So now can I turn to the statutory background, first of all, in relation to the funding bodies. In the authorities bundle, tab 3, page 25, you should have section 14 of the Education Act 2002.
Yes.
I think it's easiest if I just ask you to read subsection 1, please.
Okay. Yes.
And you'll see that the funding has to be for certain purposes. Those are given at subsection 2. I just draw your attention to A, the provisional proposed provision of education or of educational services. It might just be worth looking at C as another purpose, enabling any person to undertake any course of education or any course of higher education provided by an institution within the further education sector.
Do you accept in 14.1 the reference to person as transposed to this case is to the students doing the course?
No, my lord. These assistance is wide enough to cover assistance, financial assistance given to an education provider. I'll bring you to section 15 shortly. In subsection 14.3 on page 26, one can just see that education includes...
So person in subsection 1 is the provider of the education. Yes, is what I think.
Can include the provider of
Okay.
the education as well as the recipient of education.
As well as the recipient, okay.
Yes.
But then in 2C, for example, that person must be the student.
Yes, and to an extent, without making it express, that's why I drew it to your attention. That is an example of where no, that isn't in my submission such a limited reading of enabling any person. So
Okay.
the funding, the assistance could be given in our submission to an education provider to enable a person to undertake any course of education. But that I think, whether that's right or not, doesn't really have any significance for this case, because it can be assistance to any person in connection with the provision of education, and that would certainly cover the FECs. And there's no doubt, I think it's between the parties, that these are the provisions which the parties identify as enabling the funding agencies acting on behalf of the Secretary of State to provide funding to further education colleges. Just to note, in subsection 3, education includes A, vocational training. And then in our submission support to what I just submitted to you in relation to persons in section 14 comes from section 15, where generally it says financial assistance may be given in any form. And then you can see the examples. So I think if one looks at D, for example, that could clearly embrace financial assistance to a person other than a student to provide equipment for the benefit of the person assisted. But you'll see assistance can be given by way of grants. There's no statutory definition of grants. And in our submission, a grant means, in this context, money given by a government, by the Secretary of State here for a particular purpose. And on page 29, section 16, you'll see that financial assistance can be given by the Secretary of State on such terms as he considers appropriate. And again, I'm not sure the intricacies of the particular inclusions in that help, but you'll see at D that the terms can relate to the giving by the person receiving the assistance or financial assistance to other persons, which again is, we say, consistent with the person receiving the grant funding or the assistance being a person such as a further education college. And then turning to the statutory background to further education colleges, if I can summarise, further education colleges are statutory bodies corporate established under either Section 15 or Section 15 of the Further and Higher Education Act 1992. And that's in the bundle at tab 1. Page 4, Section 15, I think I only need to show you that. This deals with education institutions at the date of the Act maintained by a local authority. And you'll see in subsection 4, on the appointed day, a body corporate is established for each institution for the purpose of conducting the institution as from that operative date. And there are similar provisions for new institutions in section 16. And if you go to page 9, you'll see section 17. That any body corporate established under sections 15 or 16 of the Act is a further education corporation. And then on page 10, section 18 sets out the principal powers of further education corporations, and you'll see that the first, subsection 1A, is to provide further and higher education. And then below that, some powers to provide or participate in the provision of secondary education, and then the supply of goods or services in connection with the provision of education. So the key power is to provide further education, plus some powers in relation to further education, plus an ancillary power to supply further goods and services in connection with education. supplementary powers are in section 19, on page 12. And essentially, you can see from subsections 1 and 2 that these are, unsurprisingly, powers ancillary to the Further Education Corporation's principal powers. So the funding is being provided by the funding agencies under a power to give financial assistance, which can be by way of grants. So it's clearly possible under the Education Act 2002 for the funding agencies to provide grants in the ordinary meaning of the word, which are not in return for the provision to it of supplies of goods and services. And we see that the further education colleges are statutory corporations, and that their principal purpose is for providing further or higher or secondary education, and that their powers are all related to that. So this is a situation, and also, although we don't have this section in the bundle, I believe further education corporations also have the status of charities. So the sort of funding which I've described as sort of funding that can be provided under the 2002 Act, and it's being provided to organisations which have further education, higher education, their principal purpose, and which are charitable. That background, we say, is important. The Upper Tribunal considered 2020 Upper Tribunal considered that it was relevant, but also that it was neutral. I think neutral in the sense that it opened the door to a possible analysis that there was grant funding which was not consideration, but that it didn't weigh at all in favour of there being grant-funded education which wasn't by way of, which didn't involve consideration. The funds provided by funding agencies were not consideration. The 2018 first-year tribunal had found that it was a factor which pointed in favour of there being no supply for consideration. We submit that is right, but that there are other more important errors which the tribunal, Upper Tribunal 2020 fell into.
Why does it point in favour?
Well, in our submission, it points in favour in the sense of there being a economically realistic analysis of the funding from the funding agencies, which is not consideration for supply. Also, in our submission, it suggests that the way of proceeding under the 2002 Act is typically by way of a grant, albeit a grant to which conditions can be attached. Although we don't go so far as to say that the statutory scheme excludes the possibility.
You don't say it would be ultra vires to have
No.
a scheme in which each student got a bill and the government paid half of it, or the funding agencies paid half.
No. But
They can do both, isn't it?
Yes.
What they've done.
But yes, one needs to look in more detail
Yeah.
to see what they've done. But it certainly, in our submission, shows that a mere grant funding of an organisation such as an FEC would be normal. It's hard to go so far as to say it's typical. What the scheme certainly doesn't do is to, in any way, suggest that funding should favour a scenario which, in that terms, is purchasing services in return for consideration.
Well, that's why the UT thought it was neutral, I assume. It didn't favour one or other analysis on its own.
Yes, I think what the UT perhaps can be seen to do is to see a door open and then sort of rather disregard that the door has been opened. Now that may be because it has good reason for finding that there is a direct and immediate link. So I don't seek to place a lot of weight on this in my argument, and I'd rather move on and deal with our submission. Now turning to those of our submissions that relate to the Rayon door case. And we say that the 2020 Upper Tribunal erred in law in concluding that the Rayon door case, can I call it Rayon for simplicity, could not be distinguished on its facts from the facts of CIC, so it couldn't be distinguished at all. Therefore, the analysis of consideration in this case had to follow that in Rayon, and it had to conclude that there was a supply of services for consideration. There are two aspects, we say, to the Upper Tribunal's error. One is not appreciating relevant material differences in the facts. And the second is treating Rayon as not a Kenema type supply case, where...
Sorry, not treating Rayon as a Kenema.
Yes, not treating Rayon as a Kenema type supply case. Or I'm going to say, or it being significant that the CJU in Rayon had characterised the supply in that case by the permanent availability of the service provider to provide services at the appropriate time. It's possible, particularly reflecting on the Upper Tribunal's judgment in the light of my learned friend's skeleton, he would submit that I think a Kenema type supply is different from a Rayon type supply, and it doesn't matter that a Rayon type supply is a supply of the permanent availability of the service provider to provide services. I think one needs to look at the Upper Tribunal's judgment. I'll come on to do that when we come to Kenema, both in terms of whether the supply in Rayon door wasn't a Kenema supply. We still say it was. What's the significance if it wasn't a Kenema supply? We say the CJU was still characterising in reaching its conclusions on consideration, the supply in that case as the permanent availability of the service provider to make supplies, and that it must have been making that point for some reason relevant to its reasoning and conclusion. I'm going to suggest that we go to the Rayon d'Or case in the authorities bundle. It's in tab 16, or it starts at page 285. Given its potential significance, can I take you to quite a significant number of paragraphs? So, first, to try and understand what was being supplied and what money was being paid, can we start on page 289 with paragraph 12? So you'll see the yearly lump sum healthcare payment. And at paragraph 15, could I ask you to read 15 to 18, please?
Yes. Yes.
So you'll see a state-funded healthcare lump sum for medical and paramedical services, and that it's based on the number of residents in each home and the residence dependency level. When you first read relevant residence dependency level, you might think that was particularly established dependency levels for each resident, but it turns out to be based on historical coefficients at the national level. And at 19, you'll see the dispute.
Yes.
And at 22, you see Rayon's key arguments. Although we'll see more key arguments being addressed by the court later on. And then we'll see a summary of the question referred made by the CJU at paragraph 28.
Mm-hmm. Well, it's in usual Court of Justice style, it's their reformulation of the question.
Mm-hmm.
Indeed, Madam.
Yes.
And you'll see there the reformulation of the question refers to the consideration for the healthcare provided. My learned friend places some emphasis on that as a description of the service by the CAGU, it is, as your Lordship has just pointed out, a reformulation of the question. At 29, you'll see citation from Tolsma. On direct link, legal relationship, and reciprocal performance, the remuneration given by the provided service constituting the value actually given in return for the service supplied to the recipient. Could I just invite you to read 30 as it's sidelined?
Mm-hmm. Yes.
And at 32, we get the start of the court's reasonings and conclusions. 32, it's clear that the healthcare lump sum at issue in the main proceedings paid by the National Sickness Insurance Fund to the RCHEs is received by the latter as consideration for the care which they provide in different forms to their residents. And I think it's probably emerged from the parts that you've read, but it's clear and repeated in subsequent CJU decisions that, of course, the National Sickness Insurance Fund has a relationship with the residents. The residents are its insured. And my learned friend places some weight on the reference to consideration for the care which they provide. Again, as showing that the court is just characterising what's provided by RCHEs as healthcare. But we can see the reasons given for that conclusion in paragraphs 33 to 36. Could I ask you to read those paragraphs, please?
Yes.
So when one sees 33, the court is really treating this as an easy case. Essentially, it's taken the view that Roundel has accepted that there was consideration for supplies at the hearing. But it still needs to go on and deal with, perhaps one could say, the trickier bits. So at 34 and 35, there is a recognition that there can be third-party consideration and that the direct link test can be satisfied by third-party consideration, which is axiomatic, really, I think, can be satisfied. And then we say paragraph 36 is particularly important. And what the court does there first is to characterise the supply that supply services which it's considering. You can see it's specific to the supplies before it, not least because it refers to as in the main proceedings. And it characterises the supply as the permanent availability of the service provider to supply at the appropriate time the healthcare services required by its residents. And we say that characterisation must have a purpose. It must be purposeful, not without purpose. And the reference to inter alia must reflect that there are other aspects or other features of the relevant transactions. But what the court is deciding is the key feature for these purposes is that it's characterised by the permanent availability of the service provider. And in those circumstances, there can be a direct link without having to establish that the payment relates to a personalised supply of healthcare, or one at a specific time, or one carried out at the request of a resident. And you see in paragraph 37 as well, not personalised, where a payment is made in the form of a lump sum, doesn't affect the direct link between the supply of services and the consideration received. And that must be, we submit, a conclusion based on the characterisation of the services which the court has considered it necessary to make in paragraph 36. So that, in a sense, because we should look at paragraph 36 now, not just when I come back to Kenema type supplies, but you would have seen the citation of Kenema there to deal with that now. And you'll see the points I made about the relationship between the insured person and the sickness fund was emphasised in paragraph 35, or certainly noted in paragraph 35.
But would you accept that in rail it was not a mere right of access that was in issue? What was in issue was provision of a number of elements of care. So if we look back to the three elements that are mentioned in paragraph 16, you've got accommodation, dependency and care. And the payment it covers all of that. So just leaving aside care, which is obviously dependent on the condition of the individual resident and what happens to them over the course of the year, accommodation is something that they will receive throughout the year, inevitably. So it's not a mere right of access, is it?
I think there is, in my submission, there is a distinction that can be made between a right of access, such as a right of access to a golf course, where the involvement of the supplier beyond granting access will be relatively small. The supplier will be relatively passive.
But it's indifferent to whether a member uses the facilities at all. You could be a member, pay your fee, and never use the facilities during the course of the year. By contrast here, the residents, even if they never receive any health care, in the strict sense, because they have no medical conditions, they're still residing in the home. So they always and inevitably receive the accommodation element.
Yes, my firm understanding of the scope of the dispute in Rayon law, that it was a dispute about only the healthcare lump sum. It wasn't a dispute about the accommodation rate or the rate for dependency.
Well, how can that be right? Because the dependency level of the residents is specifically referred to in paragraph 17 and in 18. That's the basis upon which the court proceeds, is it not?
With respect, my lord, I don't think so. I think we're talking at the daily rate for care, or the daily rate for healthcare is being dealt with at paragraph 17, and paragraph 18 is telling us how that is calculated. So I think it's specific to that. And if one looks at paragraph 19.
Sorry, I'm puzzled by that. Can we go back to 18? The detailed rules for calculating, quote, the healthcare lump sum, take account of the number of residents hosted by each home and their dependency level, which are assessed in accordance with the conditions set out in the relevant paragraphs, and the historical coefficients. So the healthcare lump sum takes into account certainly dependency. I can see that there may be an ambiguity about accommodation, but at any rate, it certainly takes into account dependency.
Yes, I think it's dependency in terms of dependency on medical and paramedical care, as referred to at paragraph 17 under Articles R314 and R161 of the Code. I mean, the dispute in my submission does seem to be specific to the healthcare lump sum, which I've always read and understood as referring to healthcare rather than to anything else. You see that at 19, Rayon Dor took the view that the sums paid as the healthcare lump sum. There may be something else in
yes,
the judgment.
But that's the phrase in quotation. So that's the same phrase as in 18. So it must include dependency level.
Yeah, yes.
But your submission is it does not include accommodation.
My submission is it's only in relation to healthcare. That there's a, if you like, there's a distinction being drawn between healthcare dependency level and other dependency levels. For example, there could be dependency in terms of personal care, for example. And our submission is that this dispute is limited to the healthcare sum. The calculation, healthcare lump sum, the calculation of the healthcare lump sum is based on two things: the number of residents actually residing in each home, and there's a dependency level adjustment, shall we call it, or a dependency level factor, which isn't done by, it appears, assessing individual residents in individual homes, but by taking national statistics and applying them on some sort of basis of average or groups. It's not clear from the judgment.
And presumably you would say, therefore, that the reference to dependency level as an element when determining healthcare lump sum in paragraph 18 is different from the second item in the list at paragraph 16, which is a daily rate in relation to dependency generally.
Indeed, dependency other than...
Because the dependency level, presumably, you would say in 18, feeds in to the healthcare lump sum rather than being a separate daily rate.
Indeed, that's my submission.
Okay.
And getting back to your lordship's question for me, although I may better take it when I'm looking at Kenema, the essential point is that one can see that there may be a difference from the perspective of the supplier and from the perspective of the customer viewed objectively between a situation in which the supplier is making permanently available facilities and a situation where the supply is being permanently available to provide services which go beyond simply letting somebody use your facilities, which undoubtedly the supply in rayon does. It's not just making available facilities, it's being permanently available to provide healthcare. But in our submission, the important point is not becoming over-concerned about whether there's a difference between permanent availability of facilities and a service provider making itself permanently available to provide services, but doing so more actively. Because in rayon, the Court of Justice has gone to the trouble of characterising the service before it in that way, and it must have some significance. The rhetorical question is, why would it characterise the service in that way if, as the Upper Tribunal says, the same reasoning would apply to any type of service? And it does, in our submission, by citing Canema, seem to draw some sort of analogy between the supplying Canema type supplies and the supply of permanent availability of the service provider. But if it's too rough and ready to apply the label Canema supply,
well, you see, this is the question, isn't it? You say some kind of analogy, so would you accept that what they're doing is they're extending the reasoning?
Yes. Thinking on it, I think that is a fair characterization of what they're doing. They're taking Canema, they're extending it to the fact situation before it, but that isn't treating permanent availability of the service provider to supply services as happenstance and not relevant to the answer. They're extending the concept, or coming up with a very analogous concept. And the point is that for the analysis of consideration in rayon, it was clearly important that the supply was of making available, service provider making itself available to provide services, not just the provision of healthcare. And yes, one can see that you can say that it would have involved the provision of some healthcare, but that's not what the court thought characterised the supply. And what it thought characterised the supply must have been important for its analysis on consideration. So I was going to deal, I think I still will, unless you prefer me to go in a different order, to deal with distinguishing rayon on the facts and then come back to Canema. We say that the autonomy and choice available to CIC in respect of the funds as to several important matters. Sorry, let me say that again. The autonomy and choice available to CIC as to several important matters, how it used the relevant funds received from the funding authorities, is an important distinction between CIC and rayon. So as between the funding agencies and CIC.
Sorry, I don't quite understand that. Are you suggesting that CIC was free to spend the money on investing in the stock market?
No, I should explain to you.
It was obliged to use the money for providing education, wasn't it?
Yes, it was. It was obliged to use the money for providing education to students.
Right.
16 to 19-year-olds.
So what's the autonomy? I mean, autonomy, to my way of thinking, is you're free to decide what to do. CIC doesn't seem to be free to decide what to do.
It's not entirely free to decide what to do. It wouldn't be entirely free to decide what to do because it's a statutory corporate relation with its principal powers and other powers. But these are the factual points that it's free in respect of the number of students to whom it will provide education in an academic year.
But that has a knock-on effect on the grant, not in the specific year, but in the following year. So if you halve the number, you'll get half the cake the following year.
But that I think is one does need to make some distinctions between the EFA and the SFA.
Okay.
So in relation to the EFA, one receives the grant from the EFA. CIC or an FEC receives the grant from the EFA. There's no agreement between them as to the number of students who must be provided with education. There's no minimum number of students specified to whom education must be provided. So CIC decides the number. It doesn't have to provide education, further education to all students who apply to it, whether they're suitable or unsuitable. It doesn't have to supply education to all students, suitable students in its catchment area. And though we're now going to a level of granularity, CIC decides which individual students to enrol. But the more important point is a no specification of the number of students to whom it must provide courses. I'm going to come back to your ladyship's point, if you'll let me. And the contrast in Rayon is simply an obligation to provide the...
Sorry, can I be clear? Is it your submission that when we look at Rayon d'Or, there was the RCHEs were not free to decide how many residents they accommodated or provided care to?
They had to provide care to all of the residents in the care home.
To be sure, but when it came to who to admit to the care home, they had autonomy, did they not?
Yes, as far as the judgment shows.
Right. So how is that a distinguishing point?
Your Lordship's right. I think that last point took it too far. But it is, we say, a distinction between Rayon, where the obligations provide the services to all the residents in the care home. And there's nothing comparable to that.
Well, isn't it exactly the same? Yeah. Because you have the number of people you've accepted as residents in a home to whom you're required to provide medical assistance, put it that way. And you've got the number of students that you've decided to admit to your course that you're required to provide training to. Aren't those identical? Perhaps I misunderstood what you were saying, I'm sorry.
No. There, as we submitted in our skeleton arguments, it's likely that the number of residents in a care home would be fixed. So, subject to somebody dying or moving out and not being replaced by somebody else moving in, there would be, we say, likely as a matter of economic reality, to be a fixed number.
Well, there'd certainly be a maximum, but how far one felt below that would depend upon supply and demand, number of applications, etc., wouldn't it?
But
one can't suppose that care homes are always operating at maximum capacity.
Lord, submit that would be an economically realistic assumption, but I don't think I can take it farther than that. It would require, I suppose, judicial knowledge of the demand for care homes.
Quite.
Yeah. Which I accept might not be the same as in France as it is in the UK. we'd say that the second distinction is over what subjects and what courses are provided by CIC. CIC does provide different courses, and the only requirement imposed by the agreements, in practice a broad requirement, is the courses should lead to a qualification approved by the government. Again, the number of students on any given course are not agreed or fixed with the funding agencies, between the funding agencies and CIC. There are no minimums on any course. And in rail, by contrast, there were broad categories of care, but the court characterised the service as the service provider having to be available to provide all healthcare services required by a resident at the appropriate time. So that is, in the way the court has characterised it, the same service that's being supplied to each resident, although how much care is actually provided to each resident may differ.
But the amount of education supplied is the same to each person on the course.
No, there are different levels of courses with different hours.
You get different numbers of contact hours, don't you?
Yes.
Depending on your course.
Yes, and there are different subjects.
Yes.
Sorry, forgive me, Melody. I was just trying to see if I
No,
could
don't worry. Don't let me take you off your course. That's fine.
Well, just to show you, there may be a better example. But in the supplementary bundle, page 80.
Page?
80.
Thank you. Yes.
You'll see an education funding agency document. 16 to 19 student number statement.
Yes.
And you'll see that the students are put into certain bands. Maybe it's the courses we need more than students. Could you bear with me just a second? Yes, it's on page 148.
Thank you.
That you see again. If you go to page 146, the supplementary bundle.
Yes.
This is within a document that's called the Field Guide, issued by the EFA, and this is for 16 to 19 funding, and you see the title page, page 139. There you actually see the EFA funding formula, which might be useful to see set out in the original. And then over the page at 148, one does see, as your lordship said, the bandings for contact hours, annual timetable hours, which can vary, as your ladyship will see in the table.
Yes, thank you.
And then the third matter of distinction is that in our case, students have no relationship with the funding agencies. And by contrast, in Rayon, the National Sickness Fund, who was the funder, did have a relationship with the residents who were there insured and were obliged to fund the relevant care provided by Rayon, or the relevant care needed by their insured, which in this instance was being provided by Rayon. So there's no parallel of an obligation on the Secretary of State or funding agencies to pay for needs of the students in question, or the education of the students in question.
Just breaking that down, I think the third-party consideration, there doesn't need to be an obligation on the third-party provider to the service recipient, does there? For that to constitute consideration for PVD purposes.
No, my lord.
I can see that if you're trying to establish direct linkage, if there is such an obligation, it's going to help you establish that the payment is indeed in return for the provision of the service to the service recipient. But so it's a sort of factor that weighs in the balance, isn't it, rather than being determinative on its own.
It is a factor that weighs in the balance, because there does not have to be a relationship between the recipient of the supply and the third-party funder. Very often there will be. Again, this is something that one can take into account in assessing the economic realities around whether there's a direct link or not. But no, it's not a decisive point. But we say it's something that can.
It weighs in the balance on your side.
Yes. And the significance of those distinctions we submit is emphasised by the more recent case law of the CJU after Rayon. Could I take you first to the Bargaraska case, which is at the Authorities Bundle, tab 25. Starts at page 420. So this case concerned whether there was consideration in the context of the activities of a public national TV provider which received subsidies from the state. Could we go to page 426, please? Could I just invite you to read from paragraph 32, quite long, so to paragraph 37?
Thank you.
and you'll see in paragraph 37, the court makes something of the significance of the fact that there was no relationship analogous to that between the sickness fund and its insured in the case before it. Although I say that's a factor it's taking into account, I'm not trying to say that the facts in this case before you are analogous to the facts in Balgaraska, but they do fall somewhere between, we would submit, the facts in Rayon and the facts in Balgaraska. And that is because of the choice that's left open to CIC as for the number of students to which it offers education and the types of courses which it provides to them. And also, could we turn to what I'm going to call the PSA case? That's in the authorities bundle, the Advocate General's opinions at tab 27. I'd like to start there, if I may.
Yes.
It's just perhaps interesting to see how the Advocate General, this is Advocate General Cocotte, started off into her opinion. So could I invite you to read paragraph 1?
Mm-hmm.
Then could we look to see what the Advocate General says about Rayon d'Or and Balgaraska. Perhaps you could begin at 51, then read 52 as well, which is where Balgaraska, and you'll see from footnote 35, Rayon d'Or are addressed.
Thank you. So you want us to read from 51?
Just 51 and 52, please.
Thank you.
With. And I should have said, in those two paragraphs, this deals with consideration for a putative supply to the subsidy provider.
Although paragraph 52 might more naturally, in its subject matter, be concerned with the following section of consideration for a supply to the passengers.
It might, indeed. And you'll see again the court highlighting the absence of a relationship such as that in Rayon d'Or between the insured residents and the National Sickness Fund, and also on the need for identification of the recipients of the service. But again, I don't suggest that the facts of this case are directly analogous to the facts of the case before us. This case is, we say, somewhere between the PSA scenario and Rayon. Also, could I ask you to look under the second heading, consideration from a third party that supplies two passengers? Just look at 56, where Rayon d'Or is dealt with again. Just in case it's raised on behalf of CIC, there's nothing in the Garaska judgment that we've seen, or the PSA opinion, we won't see anything in the PSA judgment at all, that suggests the Advocate General and the Court are disregarding the characterisation of the service made by the CJEU in Rome itself as the making available of the service provider, be available in order to provide services. And the judgment is in the next tab, and if we could go to page 456, and you'll see there that the court picks up on both paragraphs of the AGO that I've taken you to. Sorry, I took you there straight away. Excuse me. As you've just been looking at the Advocate General, probably sensible if I just ask you to have a look at the preceding paragraphs 35 to 38, which address Rayondor.
Thank you. Yes.
And I particularly wanted to take you there for paragraph 37, given that I got slightly ahead of myself. The point was actually coming that not only have the courts up to this point and the AG not in any way distanced or departed from the characterisation. Here you see the CJU in paragraph 37 actually being at pains to point out that the characterisation was made, and we submit that it was significant for the earlier Court of Justice in Rayondor in reaching its conclusion. So those are the points of factual distinction which I wished to emphasise. Other points which are worth noting in our submission from the Rayondor judgment. I've alluded to this before. It's in many ways a straightforward case, given what Rayon itself accepted at the hearing about consideration. There were just the points that the court went on to address, particularly on third-party consideration, and as we've seen in paragraph 36. It didn't make any new law, we submit, and a sort of technical way of demonstrating that, which is that there was no Advocate General's opinion in the Rayon case. Now, the court must have considered that there was no new point of law in order to dispense with the Advocate General's opinion.
It doesn't follow. If the court had considered that there was genuinely no point of law, it would have dispatched it by reasoned order. It didn't do that. It proceeded to give a judgment.
My Lord, I was careful to say no new point of law. I do appreciate the distinction. I was relying for that point on Article 20 of the Statutes of the Course of Justice of the European Union, which I think we hadn't thought necessary to put in the bundle, but I do have it here. And I'm simply basing myself on what the last paragraph of Article 20 says, which is where it considers that the case raises no new point of law. The court may decide, after hearing the Advocate General, that the case shall be determined without a submission from the Advocate General.
Okay.
So that's what I was basing that on. I am not, with regret, sufficiently au fait with reasoned orders to be able to help with any distinction between scenarios in which a reasoned order is made and scenarios in which the court just dispenses. So my regret about that. We submit that in the circumstances, it's at least inherently likely that the particular facts in Rayon described by the court in its judgments were important to the ruling and to its reasoning such as it was. And it may scarcely need adding if you accept my specific submissions on the factual distinctions. But could I just remind you of something that you'll find in paragraph 32 of my skeleton argument, that in the VAT context, a small modification of the facts can render the legal situation in one case inappropriate to another. And that's taken from the Supreme Court in WHA Limited versus HMRC. I don't think I need to take you there, but for your reference, it's the Authorities Bundle, tab 5, page 50, paragraph 26. So at this point, can I move on to whether, in broad terms, whether the supply in Rayon d'Or was a Kenema type supply, and the significance if it was. So first of all, CIC conceded in the appeal that was decided by the Upper Tribunal 2020 decision that supplies of services of the kind in issue in that appeal, in this appeal, are not Kenema type supplies. And you'll see that at paragraph 69 of the Upper Tribunal's 2020 decision. Can I take you to the core bundle at page 199?
Core bundle.
Oh, sorry, I do beg your pardon.
The authorities bundle.
The authorities bundle, because it's CIC UT 2020. I'm grateful. So if we stay with that case, if we may, on page 200, you'll see that the Upper Tribunal comes to a very significant conclusion in terms of rayon and economous supply. It concludes that rayon door, properly understood, is not a case involving economous supply at all.
That's at 73.
That's at 73. And that, in our submission, seems to be absolutely central to the way in which it then treats rayon. And we say that that's an error of law. But could I invite you, as it's important, to read the preceding paragraphs from 70 to 72.
Mm-hmm.
So the first point that the tribunal makes in paragraph 70 is that there have been a number of references in the early part of the judgment, CJU, all before paragraph 36, when the court refers to, as the tribunal puts it at the start of that paragraph, the healthcare sum being paid in respect of the care provided to the residents. But that, of course, is accurate. Some of it, as we've seen, is in paragraphs where the court was reformulating the question that had been put to it. And at that stage may not have been looking critically at what the nature or true characteristics of the supply were. But when in giving a critical part of its reasoning on consideration, the Court of Justice considered it necessary to characterise the relevant supply by rayon and to characterise it as, or characterise the supply of the service in question as being characterised by permanent availability of the service provider to supply healthcare services. When it's reached that point, it's the first point in its judgment, when it's really necessary, vital, for it to consider and state what the proper characterization of the service before it is. So in our submission, without having to say that the court had been casual or anything other than using broad terms up to the point when it characterised the service. It is the characterisation of the service at paragraph 36 which must be seen as both accurate and significant. And at the end of paragraph 70, the tribunal reaches its conclusion because of the way in which the CJEU had described the services before it came to paragraph 36, outside paragraph 36, that the CJEU regarded the services in question as healthcare services supplied to the individual residents in due course.
Yes, can you help me, because I'm not sure where you're saying the Upper Tribunal went wrong, because at the end of that paragraph, the Upper Tribunal says it's clear the court was not approaching the RCHE's supplies as some sort of right of access to healthcare. And you accepted that earlier when we were looking at Rayon. You accepted that it was not simply a right of access case. So where is the Upper Tribunal gone wrong then?
Well, I think the direct answer to that is it's assumed because it's a right of access case. It's any case of supply. It's not, as you see from paragraph 71, to be treated as differently characterised from any other sort of service. So the thrust in paragraph 70 is that because the court has referred to provision of healthcare services a number of times in its judgment before it gets to 36, it must, when it's looking at 36, it must in 36, when it's reaching its conclusions, regard the relevant supplies as just the supply of healthcare services as described in the final sentence of paragraph 70.
So to be
And
clear,
let's say if it was...
To be clear, your submission is that the last sentence of paragraph 70 is wrong.
Yes. They simply can't be reconciled with paragraph 36, where the court has deliberately, knowingly, not haphazardly or inadvertently, said that it needs to characterise the service, and then it has characterised the service. Now, what it hasn't characterised the service as, in that paragraph, certainly not precisely characterised it as, is a supply of making available health care facilities. So it's not just a supply of access to facilities that the CJEU describes.
Right, well, this is what I'm puzzling with, because you accept on the one hand it's not a mere right of access. You say that it's wrong to say that it's a supply of healthcare services. So I'm struggling to understand where's the tertium quid that you're identifying? What's the bit in the middle that is neither a right of access nor a provision of healthcare services?
Well, it's what's stated in paragraph 36. It's tab 16, which is Rayon again, page 292. The supply of services in question is characterised by the permanent availability of the service provider to supply. I can read on if you want me the healthcare service.
So is it your submission that the result in rail door would have been the same, even if no healthcare had ever actually been provided during the year in question?
Yes, I think there are two ways of looking at it. One is, which I think we may have canvassed before, what if an individual resident, as it turns out, has a particularly healthy year or is a particularly healthy individual and doesn't need any relevant medical or paramedical treatment in the year? That's sort of more realistic possibility, I think, and the analysis would be the same. So there's still consideration for a supply. The consideration is the per person amount specified of the healthcare lump sum, because in that case you have and the service is, perhaps we're looking at service more at the moment, the service is the healthcare is realm being permanently available to provide the relevant services.
So in your submission, the key point is that, as it were, they've got staff on standby, ready to provide the services as and when needed.
Staff, equipment, medications.
Yeah, indeed, yeah. Not just
we don't quite know the parameters, because I whatever the competencies of rail on an average residential care home for the elderly, I mean, this couldn't have been envisaging, hospital surgical type treatment, I don't think, and those sort of things. But we don't know quite what it was covering. But yes. And that's important, because that enables the direct link to be made between the lump sum and the service as characterised, so that they're, if you like, at a level of generality that corresponds with each other and corresponds with economic, as a matter of economic reality. So one can see how there is reciprocity between the lump sum and the type of service that's being provided, and therefore the lump sum is consideration for the type of service. But we say the Court of Appeal must be, sorry, not the Court of Appeal, the Court of Justice must be saying that, because it must have some material impact. So the obvious and only right inference is the Court of Appeal is, sorry, the Court of Justice is saying if the service wasn't characterisable and wasn't characterised in that way, then there would not be the specific connection between the lump sum and the benefit to show the direct link that's required. Because what I don't want to get our submissions hung up on is I can show you in paragraph 36 how the Court of Justice has characterised the particular supply and issue in rail. And I can submit to you that the only logical conclusion is that was important to its reasoning. So if it wasn't that type of supply, the answer would have been different. Certainly the reasoning would have been different. We say the answer would have been different. Why would you flag up in paragraph 36 the particular characterisation? Why would you first of all need to say that the supply has to be characterised for these purposes, and then would you include the characterisation? We know the Court of Justice is never trying to be enigmatic. It's always trying to assist people who might be affected by the judgment across the European Union. And this is helpful to refer to this characterisation relating to the permanent availability of the service provider if it's impactful on its reasoning and decision. Otherwise, it's hugely unhelpful. Now, what I can't show your lordships and your ladyship in Rayon is that the court says this is a Kenema supply. I think the court is, we could probably expect being a little bit more subtle than that. It's drawing an analogy between Kenema and the supplies in Kenema and supplies in Rayon. And I think I've accepted your lordship's point that it's rather extending the reasoning beyond sort of mere supply of facilities in Kenema to the characterisation of supply that it's identified in paragraph 36. But what the Upper Tribunal admits is no weight at all for the significance of the characterisation in paragraph 36, which just can't be right in our submission. Now, the tribunal, and I think your lordship believes that I've effectively said this already, the tribunal may be right, perhaps your lordship thinks I said they are right, in saying that a right of access to healthcare is not the way in which the Court of Justice characterised the supply in Rayon. So I think it's drawing an analogy between the sort of supply in Kenema and the sort of supply in Rayon, but it was extending that analogy. But at the end of 70, the tribunal, paragraph 70, the tribunal's got itself into a position where it's rightly or wrongly rejected the supply as a Kenema supply and said it's just simply a supply of healthcare services, because that's the way the court's described it in the early paragraphs of its judgment. It's giving no heed or weight to paragraph 36 at all. And in paragraph 71, it says that it doesn't understand the reference in 36 of Rayon, services which is permanently available, the characterisation of Rayon supplies as Kenema supplies, as distinct from any other type of supply for VAT purposes. So it says that the tribunal is, the CJU is just adopting some sort of different words to describe what it really sees as just a simple supply of actual healthcare services. So it characterised the services provided by Rayon as services provided year on year, their residents, whoever they may be from time to time, on a rolling basis. But that doesn't fit with what the court said in our submission. It leaves out the very important characterisation of supply as being permanently available to provide services. And we say that to see the 2020 Upper Tribunal's error, one doesn't have to go outside Kenema itself, Rayon itself, if you have proper regards to paragraph 36. But we think that's now clearer still from more recent CJU decisions. So still in the authorities bundle, actually it's the next tab. Could I take you to tab 17?
I mean, this had been decided before the Upper Tribunal's decision, hadn't it? But the Upper Tribunal weren't referred to it. Is that right?
On the 3rd of September 2015, yes. I didn't refer the tribunal to it. I became aware of it looking at the case for another point in another case. It was, if we perhaps go to paragraph 36 on page 300. And you'll see there that it was concerned with subscription contracts for consulting services and a fixed payment in return for a commitment to be permanently available to the customer. That was the service issue in the main proceedings. That's how the CJU in, may I call it ALIC, A-L-I-C, characterised it. And then can I invite you to read paragraphs 37 to 40. So, again, looking both at the Kenema case and at Rayon d'Or, the court in ALIC is trying to find what's significant in those judgments. And it refers to supply of service in question characterised inter alia by the permanent availability of the service provider in order to supply at the appropriate time services required by the customer, not necessary to find that there's a direct link between the services and the consideration received, establish that payment relates to a personalised supply of services at a specific time carried out at a specific customer request. And then in the final sentence, the service is irrespective of the number of services provided and received in each case, the number of rounds of golf played, or the amount of care provided. So I think it's clear that the court in Alex is seeing the Rayon d'Or as an extension of the court's earlier reasoning in Kenema, or it's rather running them both together, which is why I don't drop my submission that it is a Kenema supply that's being made in this case. But it chooses to use the developed and perhaps, I think we are saying, extended language that's used by the second court in Rayon. So, as we've seen from 36, the court is applying paragraph 40 of Kenema and paragraph 36 of Rayon to allow a direct link where we would say there would not otherwise be one because of the character of the services. That is, the commitment to be permanently available to the customer, if one puts it in those general terms. So it's a regret that this case wasn't available to the Upper Tribunal, and we submit that its impact is clear. Now, in its decision, sorry, paragraph 72, its authority is 200, back to the Upper Tribunal 2020's decision. The tribunal says that it would be surprising to them if the court held that a different rule should apply just before a transaction happens to fit the Kenema model. I'm not quite sure what the tribunal means by a different rule, because we weren't trying to suggest that the direct and immediate link rule, the need for reciprocity between the service supplied and the consideration received to it was a different rule applying in permanent availability or Kenema type cases to the normal rule. It was just that where a supply could be characterised in the way in which the Court of Justice had done it in Rayon, it was possible, because of that characterisation, to find that direct link and that reciprocity where it wouldn't have been possible if the supply was not of that character. Therefore, it was, we said, fundamentally important that the supply in CIC, it was common ground, was not of that character. And that's a fundamental distinction between the Rayon Door case and CIC UT 2020 in the present case. Just need to look at some further support the tribunal found for CIC not being a case involving a Kenema supply, or I would add, just to keep it on the straight and narrow, making supplier, service provider making stuff permanently available case, and that was found in a case called Saudasur. Saudasur is at tab 18 in the authorities content. I'm going to take you to paragraph 36, I think. Could you bear with me just a moment? Yeah, sorry, I was in the Advocate General's opinion, and I wanted to be in the judgment. I think it's the argument was that and Mrs. Hall, then counsel, Miss Hall, now KC, then counsel for Saudasur, took the tribunal with her along this line, that Saudasur did not involve a Kenema supply, and it plainly didn't involve a Kenema supply. Although the tribunal itself said at the end of paragraph 73 that it didn't think it was necessary to look outside Rayon Door to understand its judgment. But it's hard to see why Saudasur can be dismissed as not a Kenema supply, or perhaps better put, a supply being permanently available to provide services. And on page 332, paragraph 36,
this is different again, isn't it? Because here it's permanent and continuous nature of the planning and management services provided. So this is not mere availability on standby. This is permanent and continuous provision of services.
Yes, I was in the case, and it was really a case of one public body outsourcing to a public company its planning and management services. I think I hear what your lordship says about different phrasing being used, not permanent availability, but permanent and continuous nature. But in our submission, that fits with permanence and availability of the service provider.
The AG does use very Kenema language and cite Kenema, doesn't he, at 53?
Sorry, I didn't quite hear what your lordship said.
The Attorney General uses very Kenema-type language and cites to Kenema at para 53 of the opinion.
Oh, I'm grateful. Paragraph 53
Page 318.
is on page 318.
Citing to Kenema and Round Door.
In so much as the different phrasing that I took you to in paragraph 36 is could be used to complicate matters. It's clear that the court is drawing on what the Advocate General said then, there's no suggestion based on Salasor or any other case from the respondent that it is actually in a Kenema type or making available type situation.
What would you say to the proposition that actually the point the court is consistently making throughout this case law is a negative one, viz. That it does not matter that payment takes the form of a lump sum or flat rate annual sum, which by definition cannot be referable to the specific services provided to specific recipients, precisely because it's a lump sum or flat rate.
Well,
and the court is saying repeatedly that doesn't matter. You can still have a direct link.
I see why your lordship puts it in says it's presented in a negative way. But what the court is saying in our submission is, in that scenario, things don't have to be shown, which would otherwise have to be shown if the supply is not characterised in that way. So it's the characterisation of the supply which allows the direct link with a lesser degree of specificity than will be required for the ordinary supply, which can't be characterised as making available supply. It's clear that the court isn't saying you're no worse off because you're making a supply that's been characterised in this way. It is saying in our submission that because the supply has been characterised in this way, requirements which would normally have to be met do not have to be met. And I don't think it's helpful to trouble you with my description or trying to take you to passages in which the services in Sadasur are more precisely defined. We do say that the characterisation of the supply undertaken by the Court of Justice in Rayon, and we see it again in ALEC, for example, of whether or not a supply of services is of the type of the service provider being permanently available to make supplies. It is significant for reciprocity and direct link. It goes to the reciprocity between payments and a specific individualized benefit to the recipient of the supply. So where there's making available type of supply and a lump sum payment, the CJU has been willing to identify reciprocity and a direct link between that lump sum payment and the supply of the service made by the supplier. And we do submit that the CJU is drawing a contrast between the requirements to satisfy the direct link test in a Kenema type case, and in other, I'd say in a making available type case, and other non-making available type cases where it's simply a straightforward supply of services. I think, as I said before, but I'd want to reiterate, I think, it is in line with an economically realistic approach to the direct link. And as we know, the economically realistic should be informing us when we're conducting VAT analysis, including analysis as to consideration. It's economically realistic to link a general lump sum payment in respect of a period of time to a supply characterised by the permanent availability of the service provider to supply services for that period. The relevant direct link of reciprocity is apparent at that level on the facts without need for greater specificity. But in those cases that we've been looking at in the last few moments, there's no suggestion that that approach to the level of specificity needed applies more generally outside the service provider making himself available to make supplies over a period of time case. It doesn't fit with the CJU's reasoning in Rayon for what it says in paragraph 36 to apply generally rather than specifically to the types of supply it is there characterised. It's clearly not a general point in paragraph 36 being applied by CJU to all supplies of services. Now, my learned friend's skeleton at paragraph 56 and following contends that HMRC's characterisation of the supply in Rayon as being exclusively the permanent availability of the service provider to provide healthcare, as opposed to the provision of healthcare itself, as a false dichotomy. I think it's convenient to deal with that now. It doesn't appear. So I think what my learned friend is submitting is that there are two elements to the supply. One is standing ready to provide services, and the other, the actual provision of services. My learned friend doesn't appear to contend that those would be different or separate supplies of services, as opposed to elements in one supply of services by a service provider to the recipient of the supply. So, if that's right, my learned friend, and it would be wrong to try and analyse separate different supplies. The point remains that when, for the purposes of considering consideration and the direct link, the Court of Justice of the European Union and Rayon considered it necessary to characterise the services. The CJU did it in one way. It did it only in the permanent availability way. It didn't say there are dual character services being provided here. For the reasons I submitted the CJU's characterisation that is significant, the permanent availability characterisation, and not my learned friend's attempt to bring a new characterisation to the supplies. And as I submitted earlier, in paragraph 36, the court did refer to, the court in Rayon did refer to inter alia, but it was clearly considering all of the characteristics of the relevant supplies and deciding them how it should be characterised and characterising it in the one particular way that we see in paragraph 36. So my learned friend's analysis of dual character for the purposes of addressing consideration and direct link simply can't stand alongside the analysis of the Court of Justice in Rayon d'Or. And to some extent, my learned friend was building on paragraphs which start at on paragraph 47 of the skeleton argument. That's called under paragraph 47. Sorry, core bundle page 47, I do beg your pardon. Perhaps I should just look at 46, because you see there the heading services. Mm-hmm. So, if you look at paragraphs 29 and 30, might I give you a moment to read them?
Yes.
So the reasoning is that a service can be the actual provision of something to the recipient, or it can be the right to such a benefit, or it can be both. So there can be two services, the confer of the right to benefit and the provision of actual benefit. So the first point to make again is that when one looks at the approach of the CJU in Rayon, it didn't identify that the supply could be characterised in that dual way. And I'd just like to go to one of my friend's first example of Air France KLM. He says the same point is explained in a later case in paragraph 32. So I'm only going to go to the Air France KLM case. That's in the Authorities Bundle, tab 19. Can you go to page 345, please? And have a look at paragraphs 20. Would you be kind enough to read yourselves paragraphs 26 to 29?
Mm-hmm.
So you would have seen that in paragraph 28, when trying to identify the consideration and the service, the court concludes that the consideration, I think, the consideration for the price, and therefore the service, I think, consists of the passenger's right to benefit from the performance of the obligations arising from the transport contract. And you've seen in paragraph 26 that those involve all sorts of actual, the actual, as we all know from common experience, air transport involves actual services. Being embarked onto a plane, the plane taking off, the plane flying, and the plane landing. But whilst the court's clearly recognising that, it characterises the relevant supply here, not in a dual manner. It characterises it in a single manner, a supply of rights to benefit from performance.
Well, I can see that if my golf club subscription allows me to book and turn up and pay a reduced green fee with the privilege of paying, it is meaningful to speak of me having both bought, in general, the right to play at that rate in the course of the year, and specifically a separate service of actually playing on a particular day. But where there aren't separate, as it were, considerations for the right and its use, just wonder how relevant that is to the present debate.
Well, in my perception is that my learned friends are trying to leverage that up into something relevant in terms of the analysis of consideration and direct link in this case. But this case gives no support to the dual analysis that my learned friends contending for in this scenario. And I take your lordship's point about the golf club. But in our submission, it doesn't advance his case at all. Well, I'm about to move on to my submissions on our ground 2. There's not much time before lunch.
In relation to that, how much more have you got? How much more time?
I think just over an hour.
Okay, so on that basis, we will recommence at 2 o'clock.